It's like, you know, abstract dance, performance art. There you go.
Hello, and welcome to another author event at the Pleasanton Bookstore. I'm John Charles, and we're delighted to have with us two very special local speakers. I have notes because they're both so accomplished I can't remember everything they've done. Before I introduce our guests today, I'd like to let those who are attending us in person and those online know that we do have copies of Manifesting Justice available. We would be happy to put one in the mail to you or hold one at the store. The author, Valeena, Beety, is very graciously signed them, so if you're looking for a gift this summer or something to read yourself, do think of that and give us a call or go online. Now I would like to welcome Valeena Beety, who is a former federal prosecutor and innocence litigator who represented Lee Stubbs for post-conviction. She is a member of the Presidential Grants of Clemency for Drug Offenders, has served us on the elected board as an elected board member of the National Innocence Network, and was appointed commissioner on the West Virginia Governor's Indigent Defense Commission. She is currently a professor of law at Arizona State University Sandra Day O'Connor College of Law and deputy director of the Academy for Justice, a criminal justice center at the law school that connects research with policy reform. Ms. Beety is joined today by award-winning audio journalist Sarah Bentley for a conversation about her new book, Manifesting Justice, Wrongly Convicted Women Reclaiming Their Rights. And I'd like to add that Ms. Beety has graciously said she will be donating the equivalent of 10% of the proceeds of any book sold related to this event to the Native American Rights Fund in acknowledgement of Ms. Bentley's work on the Peabody Award-nominated second season of This Land. Now, please join me in welcoming Ms. Beety and Ms. Bentley.
Oh my gosh, thank you so much everyone for coming, and I just feel so honored to see people I know here, so thank you. And thank you to the people virtually as well. And thank you to Sarah for doing this event with me and her amazing work on This Land, and also on her other podcasts that she's been working on as well.
Thanks so much for having me. I am so honored to be here and talk with you about this book. I know we have lots to talk about and lots to converse about, but let's start by having you maybe just read a little excerpt from the book. Maybe you can just kind of let folks know kind of what the concept of manifesting justice is.
Yeah, thanks. So the book, as some of you may know, is focusing on the story of my client Lee Stubbs and her co-defendant Tammy Vance, who were wrongly convicted in Mississippi because they are lesbians, so because of homophobia, because of bogus bite mark evidence, so evidence that we might think is valid because an expert testifies to it in the courtroom, so a jury may rely on it, but turns out to be completely false. So that combination led to their wrongful convictions. And I just wanted to read some excerpts of the testimony that was given that led to their wrongful convictions, because it's very compelling. And you know, imagine these are experts who are sharing this information, and you can see how a jury would find them guilty. And what has happened is Lee and Tammy and a friend of theirs, Kim, were all in a drug rehab program. Lee and Tammy graduated from the program and were leaving, and their friend Kim said, "I'm done with this, can you please just take me with you?" And they did, and soon after, Kim and Tammy take some OxyContin pills that Kim has taken from her boyfriend, and Kim overdoses. So they call 911 and have her taken to the hospital. And at the hospital, there are signs of like a sexually aggressive encounter. There's like paddle marks across the back of Kim's body. And interestingly, a dentist, Dr. West, is brought in to examine Kim's body while Kim is in a coma. And as my students may, I know we've talked about the rights of women and bodily integrity in our classes. And Kim is unconscious in a coma, and here's this doctor looking at her entire body naked. and he finds bite marks. So here is Dr. West's testimony, the dentist, about the bite mark evidence. Dr. West, is there any question in your mind that the injury on the hip that you've discussed was, in fact, a bite mark? Lampton asked. In my opinion, the mark on her hip, within reasonable dental certainty, is a human bite mark, Dr. West replied. I give my strongest opinion of positive. Lampton, the prosecutor, continued. So in a homosexual rape case, you would expect to find bite marks. It would not be unusual at all to find bite marks on the skin. No, it would not be unusual, Dr. West answered. In fact, Lampton asked, it would almost be expected. Almost, West replied. So that's the testimony of the expert for the state. And then we have the defense expert, Dr. Galvez, who you would hope would give some different testimony. So here is our prosecutor, Lampton, saying, Dr. Galvez, good to see you again. You've testified in this court. You've sat in that chair before. Mr. Lampton, I am under oath, and I have to tell the truth. I already had the honor and pleasure to work with you, Dr. Galvez said. Thank you, Lampton responded. And I take you as a dear friend of mine, Dr. Galvez added. We've known each other for several years, to say the least, Lampton confirmed. 25 years. Your hair was dark, so was mine, he chuckled. This verbal hugfest did not bode well, and things went downhill from there. Would you expect to find biting, or would biting be consistent with a lesbian rape type situation in a homosexual rape? Lampton asked. Yes, Dr. Galvez confirmed. In homosexual crimes, they are very sadistic. Most violent times I've seen in my experience are homosexual to homosexual. They do what we call overkill. They do tremendous damage. They are brutal assaults, Lampton suggested. Yes, sir, Dr. Galvez declared. They're more gory, the more repulsive crimes I've ever seen were homosexual to homosexual. Dr. Galvez's testimony capped, some would argue it sunk, the defense case. Tammy's attorney did not call a single witness. And then finally, we have how the prosecutor summarizes all of this evidence to the jury. So Lampton wrapped it up. When you look at all the evidence, you'll realize that while it's a circumstantial evidence case, these two women who were living together were lovers. And whether because of the drugs or the alcohol or their lifestyle, they viciously attacked Kimberly Williams for no reason and tried to cover it up, Lampton said. Lampton told the members of the jury that the evidence was clear, as was their duty, to consider the evidence presented. And that was the evidence presented to them. And so the jury found them guilty. I feel like I've already been talking a lot, but I do want to say about the manifesting justice thing.
No.
So Lee and Tammy did not have DNA evidence in their case. And in my experience as a person litigating innocence cases, wrongful convictions cases, if you had that DNA evidence, that's your gold ticket. That's how you get relief for your client. But there's a lot of innocent people who do not have that evidence, and the standard of proving themselves as factually innocent is a very, very high standard to meet. So the title comes from my legal argument that the standard should be one that is lesser known and lesser used, but is manifest injustice or miscarriage of justice, and looking to see whether we can believe in the validity of this conviction, whether so many things have gone wrong in the case with experts falsely testifying, with police falsely testifying, with prosecutors not turning over exculpatory evidence, that undermines the reliability of the conviction, rather than can they reach that high level of factual innocence. So that's where the title comes from. Whew.
Well, thank you so much. I know it's like you just like helped us dive right into the like meaty, horrible, difficult parts of that case like right away. It's so much. It is so much. So can you talk a little bit more about the concept of manifest justice? So this is something that you say, well, I mean, also in the book, you make a lot of recommendations about ways that things can be reformed so that a person is not wrongfully convicted.
Yeah.
And so in a case where you are arguing for something like manifest injustice, this is something that happens pre or post conviction.
Ooh, thank you.
Yeah.
So a lot of innocence work, we say that our goal is to stop wrongful convictions from happening. So how can we change how police interview eyewitnesses, for example, or how police gather evidence, or disclosure of prosecutors and their evidence that they've gathered. So how can we change those things beforehand? Manifest injustice, miscarriage of justice, is a post-conviction remedy. So it's going back, and I particularly talk about the structure in Massachusetts where the courts say, let's look at all of the problems. Like instead of, okay, the experts provided false evidence on the stand. Is that one thing enough to reverse the conviction? They say, let's look at all of these elements together. And when you really look at all the problems in a case together, you're able to identify a wrongful conviction more easily than just, okay, so maybe you were wrongly picked out of the lineup, but that alone is not enough. There is another remedy pretrial, which is dismissal in the interest of justice. And we saw that happening in 2020, in that summer with the riots, where there would be mass arrests of, not riots, I should not have said that, I did not mean that. In the summer of the protests,
yeah.
Thank you, I really misspoke there, where you'd have mass arrests of protesters by officers who were trying to clear the streets, and there wasn't necessarily anything that each individual person had done wrong, so we saw dismissal in the interest of justice there. Yeah.
So can you talk a little bit about, I feel like in this case, some of the most obvious ways that we saw a miscarriage of justice was in the fact that this case relied on so-called science that turned out to be not really science, and it relied on expert witnesses or expert testimony from people who weren't really experts. How often does that kind of thing happen in a criminal case?
It's one of the leading causes of wrongful convictions, is like false evidence that is presented. Yeah, it's surprisingly high. And I should have put pictures in this book so that people could see what bite marks look like, because it can vary tremendously based on someone's skin, right? It's about how long has it been since the bite happened, like what is the person's skin like, and it can just be a big red blob. And you look at that and you're like, well, how are you gonna match a dental mold to that blob? Like, how are we gonna know if it's Sarah's teeth or my teeth or Jen's teeth? This is my wonderful wife here, by the way, Jennifer Leva. Thank you for being here. So how are you gonna tell? And it comes down to, well, the teeth marks or the dental mold that you want to match is what's gonna match. So bite marks are particularly frightening, and they still are admitted in court today. So no courts have excluded or stopped bite mark evidence from coming in. It's really on the prosecutors, and whether the prosecutors themselves say, this isn't reliable evidence, we're not going to use it.
But that seems really complicated too, because it assumes that prosecutors or even defense attorneys are able to sort of understand enough of the science to say, wait a second, something about this seems questionable. And given that there's so many different types of scientific or medical evidence that's presented, that seems like a lot for an attorney who has a very different set of expertise to take on and understand. So how do you get to the bottom of that?
Yeah. So our courtrooms have really changed, and prosecutors and public defenders, as well as civil attorneys, it's often part of the job to be able to talk with an expert about scientific evidence, and to have some rudimentary knowledge. I mean, there's a joke like, oh, you went to med school or you went to law school because you're bad at math or science or whatever. It's funnier than that, but I just don't think that's possible anymore because so many convictions and civil cases rest on expert evidence, forensic evidence, scientific evidence. So I think it's important for all people in the courtroom, including the judges. So many judges now have trainings on forensic evidence so that they can have a better understanding as well. And it's just, if it's a component of convictions, if it leads to convictions, then it needs to be at least understood by the prosecutors using it.
Yeah. So you do talk a lot in this book about the responsibility of the prosecutor and the power of the prosecutor and the fact that if we really want to think about creating a criminal justice system that's more just, we have to think about what is the role of the prosecutor, what can they be doing differently to create a more just system. And so we should say, in the interest of full disclosure, you used to be a prosecutor.
Yes, I did.
So do you want to talk a little bit about how you made the choice to become a prosecutor, and then what made you decide to kind of leave that and argue as a defense attorney? I actually have another excerpt I'm going to read that is about that. But I went to law school because I had been a rape victim advocate in Chicago. So I was on call to respond to hospitals when a survivor of sexual assault came in, and I advocated for them. And I wanted to prosecute sexual violence and domestic violence. I was also a DV counselor. And that was why I went to law school. And I got my dream job. I mean, I got the job being able to do that. And that's when I learned that job was not a fit for me. So it's not too long. After working as a rape victim advocate, I knew that I wanted to become a prosecutor. I saw how violence impacts survivors. I wanted to end the cycles of violence and stop the perpetrators. I thought prison was the answer and that I could be a protector. So when I was 27 years old, I made a big move to Washington, D.C. There, I would finally start my career as a federal prosecutor. I was confident, I was righteous and excited, armed with my newly minted law degree and my job experience clerking for federal judges. I was proud to be an assistant U.S. attorney in the nation's capital and proud to be fighting for others. But that wasn't necessarily the job. My year as a prosecutor brought me face to face with how prosecutions did not always help victims. In fact, victims often resented me. Of course they did. I quickly learned to have the police arrest victims in order to make sure they showed up in court to testify against the defendants. That was just one of the common and callous tactics adopted in the office. And yet, I continued to cloak myself in a shroud of righteousness. I never thought about being wrong. I didn't think about charging the wrong person as the perpetrator or about prison as the wrong solution. I was averse to compassion or sympathy for anyone other than the few people and few situations I decided deserved it. So being a prosecutor is a very powerful position, and that can be for good or not as much. So. Can you talk a little bit about the ways in which being a prosecutor is a really powerful position? So I have interviewed Valeena for a project I'm doing, and we talked a lot about kind of, what is required of the prosecutor, what is required for someone to be found guilty or innocent. And I felt so embarrassed because I feel like I had this extremely naive idea that, for someone to be found guilty of a crime, it has to be beyond a reasonable doubt. That's such a high burden of proof. Like, everybody's innocent until proven guilty. And like, of course, there are systemic things that happen that like give people not a fair shake, and we definitely need reform. But then you outlined some very, very specific things that I had no idea about. Like, for instance, that prosecutors can ask for DNA evidence to be to be evaluated. Defense attorneys cannot do that unless they get permission of the prosecutor. And then there were a whole bunch of other things that were like that just made me go, oh my gosh, like I knew the deck was stacked against a lot of people. I did not understand to the extent in which that was true. So can you talk a little bit about some of those things that people might not think about?
Yeah. So one is that prosecutors are supposed to turn over what's called Beety evidence. So evidence that is material and exculpatory. And our Supreme Court has now decided that if evidence is exculpatory, but it's not important enough, it's not material enough, then it doesn't have to be turned over. So again, it has to be exculpatory and material. And prosecutors don't have to turn that over until right before trial. Well, 95%, just broadly speaking, it's more than that in some states, 95% of cases nationally end in a guilty plea. So that evidence doesn't have to be turned over before the guilty plea. So there could be evidence that shows I am innocent of this crime, and my attorney says, just take the plea. They're giving you a good offer. You could get something far worse if you went to trial. Take the plea, and I take it, and they have the evidence the whole time, and they never had to turn it over, and that's legal. That's completely legal. So again, I mean, you can see the power for good that prosecutors have, right, to really protect our communities. But it can also, it can go the other direction as well.
Yeah, and just to be clear, I didn't want to diminish the power of those systemic things like racism, sexism, homophobia. I mean, those things are massive and huge. But I think I just didn't understand that procedurally, there were also all of these steps that can happen that make it very difficult for a defendant to come out of this in any way that's not with them in prison. Yeah. So, and also this idea that 95% of these cases end in a plea was really, really, really shocking to me.
Yeah.
Can you talk a little bit about, I guess maybe in this case, I don't want to give away too much about the ending of the book or where the case goes, but I know there were a couple of opportunities where these defendants could have taken a plea and had to make a difficult decision about whether or not they should. How does someone weigh those options?
So, as the attorney, it is never my decision on that. It's really the client's decision. So I may say, once a conviction is reversed and they're bringing the charges again, let's say, we should take this to trial. We can absolutely prove that you're innocent. Let's do this. But if the prosecutor is offering a plea to time served, like if you just plead to this lesser offense, you walk out of prison, you don't have to go back, you're done. I've definitely had clients take those pleas, right? Because they've been wrongly convicted before a jury once before. So once that's happened to you, you're like, that could happen to me again, and it's not worth the risk. And so they take a plea. I mean, my question on that is always, if you're the prosecutor and you're offering a time-served plea, okay, which again means, you were charged and convicted of murder. That conviction was reversed. And now if you plead guilty to felony assault or manslaughter, we'll let you walk free. You can be free for the rest of your life. Well, how much do you really believe in that conviction, right? If you actually think that that person murdered someone, then why would you be saying, okay, yeah, if you just plead, we'll let you walk free? So I think there's a conflict there.
Yeah, and the idea that someone's conviction can be overturned and charges could be brought against them again. How common is that? That seems like it's a pretty common thing to happen too.
It is pretty common, because when you get relief, so I know I'm talking about this like miscarriage of justice relief, you get your conviction reversed, the state can that means you get a new trial, right? Like the state can rebring the charges. It means you get a new trial. It doesn't stop the state from recharging you. So yeah, frequently those charges are brought again, and then you see these pleas where people plead to time served.
And I know one of the things you and I have also talked a lot about is the concept of a trial penalty. Can you explain what that is?
So, so if 95% of people plead guilty, do we think that our system, like that 95% of those people actually did it, or is that the easier solution? Like, oh, if you plead guilty, we'll drop this charge down. You'll only get a certain limited amount of time. If you go to trial, we're going to throw the book at you if we can. We're going to ask for the harshest penalties. And so this is generally talked about as a trial penalty, that you have a penalty if you take your case to trial. And I wonder, Sarah, if you want to share anything about, or how much you can share about your own work and project, kind of looking at this as well.
Yeah, so I'm an audio journalist. I make documentary podcasts that sometimes involve things that go through the criminal justice system in different ways, not just criminal cases, but sometimes civil cases or tort. And so, yeah, I think for me, when I'm looking at a story that involves someone who, like I've interviewed a lot of people who said, oh, like, I was arrested. I had this like really scary thing happen to me. They brought all these charges against me. I didn't know what to do. And then I was kind of told, or like I got the impression that I really just needed to take this plea deal, even though I didn't feel like I was guilty of these crimes, because it was the best offer that I was going to get. Or like, oh, I did, I was a part of this one thing, and then it turned out there were like, 6 charges against me, and how is that possible? And so I think, I guess in my work, I've definitely talked to people who feel like they were overcharged, feel like they were forced to take a plea, feel like they didn't have like a lot of options outside of that. And then with these other systemic things that we've talked about, racism, sexism, homophobia, that all of these isms work against so many people, and that if you don't have access to be able to pay for really, stellar representation on your own, even if you have an amazing public defender, that you may not be in a great position. So yeah, I mean, I've definitely spoken with people who like talked about that, and we talked a little bit about that concept of overcharging, and prosecutors routinely going through this process of overcharging clients for crimes. And you shared a really interesting and disturbing anecdote with me about your classes.
Oh, yeah. So for I actually, yes. So you have definitely been in criminal law with me. So I do these exercises in criminal law, a mandatory class, where the student is supposed to be the prosecutor, and so reads this whole case file and decides what charges to bring. And routinely, and then they're supposed to negotiate with someone on the defense for what kind of an offer they will give. And routinely, they will bring the harshest charges they can. They'll, hold firm, and they'll explain that because they'll say, oh, well, yeah, because in the negotiation, then I can negotiate down to what, I really want, or what I think is a more legitimate, valid charge. So these are people who are just starting law school, and they're already kind of primed that the criminal courtroom is like a game, is like a competition where you try to win as many charges as you can. And it's just interesting, like they haven't finished law school yet, and already it's this, well, bring as many charges as you can so you can, win and make them stick. I mean, I have one of my former TAs here, Victoria. I don't know if you have any thoughts on that exercise. Like,
yeah, I agree with everything you said. It's so interesting that you're already primed going into law school thinking that you want to win the highest possible charge that you can instead of starting with what's good.
Yeah, right. And again, like what's creating safety for our community and hopefully ending criminal behavior.
Yeah, I thought that was really interesting because I always think of first-year law students as being so idealistic. And then it's like, oh gosh, but the system really is set up that someone wins and someone loses.
Yeah,
and,
it is set up that way.
And that was really that was something I hadn't thought about in that way before.
Yeah.
So you talked a little bit about how you made this transition from being a prosecutor to working on the defense side of things, working for the Innocence Project. Can you talk about, there are some examples of people who do the reverse, right? Of people who start as defense attorneys who end up looking to become prosecutors.
Yeah, and that's been in the past 5 or so years. There's been more innocence litigators who have returned to prosecutors' offices and become elected prosecutors, established what are called conviction integrity units, where they look at convictions from the office to make sure they didn't make a mistake. So there's been a couple of prosecutors who have done that, and I think I had something in here. So Parisa Degani-Tofty is, she's the Commonwealth prosecuting attorney, the elected attorney in Arlington, Virginia. But her parents actually live in Prescott, so nearby. And she's a former innocence litigator. And she really talks about how her experience makes her be able to work with victims better and be a better prosecutor. So she says victims only sort of start healing after convictions based on the way that the system is currently set up. So she really tries to have something that is more healing and rewarding for the victims. And then she really is committed to this kind of restorative justice. And so I asked her about, the role of prisons and restorative justice for a prosecutor who seeks accountability. And she says, bringing in a restorative process can help bring about the kind of accountability that we pretend that prison does. I think that people who have those kinds of thought processes to really better themselves and make good on the wrong that they've done are having them in spite of the way that the system is set up and not because of the way the system is set up. And it's okay to admit that we sometimes need to use prison as a tool of incapacitation and punishment, but I think it's not okay to pretend like that is true accountability. So she brings her own innocence experience to more broadly know that even years after a conviction, the victim may not feel healed, may not feel solace from that conviction, and that we need to look at other ways to stop criminal behavior instead of or in addition to prison.
So I do think that's kind of interesting, just to think that people maybe with that mindset or with that perspective could be the ones going into positions of power, positions of authority, elected positions, even where they're kind of redefining how we think about justice and incarceration.
Yeah, and so I directed and founded the West Virginia Innocence Project, and I had students working on cases, and I would love having students who were committed to becoming prosecutors, because I knew that they were going into that job knowing some of these pitfalls that we've discussed, knowing that it's important for a conviction to have integrity and how to make sure that happens. So I think it's been really valuable to have innocence litigators who, again, I mean, the point of innocence work is to free people who are wrongfully convicted, but to stop wrongful convictions from starting in the first place. And so if you know that and you're able to implement some of those changes in your office, it's a big deal. And okay, good. Just making sure we have time.
Yeah, I want to make sure we leave plenty of time for questions. So I think I want to say before we close, I have one last question for you. But I also want to say that one of the things that I think is so smart about this book and the way that it's written is that it really takes you along a journey. Like, it is a story. It is a story of people who were wrongfully convicted, and you feel as though you are kind of discovering things along with the attorneys, along with the defendants. And so I know sometimes when we talk about these things, it can feel big or abstract, but I really appreciate that there's such a human face to this, and that it really is a narrative story about some really big, complicated issues, but that it is also like it's a difficult read in the sense that the things that happen to people are very hard to hear. But it is also a really compelling read, and one that did not feel like an academic book or something like that to me. It was just like something that I enjoyed being able to kind of hear the story and hear how a wrongfully convicted person navigated this incredibly complicated system, with the help of some really incredible attorneys. So congratulations on that. My last question before we open it up to the audience is, so given everything that you've said about the ways in which injustice plays out in our criminal justice system and the difficulty of trying to argue for people's innocence, the complexity of all of these systemic injustices that are baked into the way cases are playing out, how do you maintain faith and hope, and how do you continue to do this very difficult work, even knowing that it is constantly going to be an uphill battle?
So, I just got a filing, and Jen was like, "You take these things so personally," and I still do. I still take the work personally. But I think there are a lot of smaller things we can do and that matter. And I actually, I don't know if I have the page for it, but in the back of the book, I think I do, I have a checklist of tools, because there's so many different areas that we really can change things. So here with our referendums in Arizona. So for a couple of years, if you had a medicinal marijuana card, you couldn't be criminally charged and sent to prison for having marijuana. So if $200, if you could buy that card, you'd be okay. But if you couldn't afford that card, then you'd be spending at least a year in prison for the exact same issue. Mm-hmm. So we had a referendum, now we have recreational marijuana. There are a lot of different things across the board that can be done. One of the reasons I wanted to make this whole checklist. There's things we can do as civilians, not just as lawyers. I will say the hardest chapters in the book are the first ones on like habeas law. So if you make it past that, it's an easier read. But I think that's part of it, is just being able to do different things. And I'm so fortunate to get to be a teacher and work with amazing students, and know that you all are going out and are doing your own great work in the world. And that's super rewarding too. Yeah.
Well, thank you so much. I'm so glad that this book exists in the world, and I'm so honored that I got to be in conversation with you about it. And I'd love to just open it up now for anyone who has questions. And if an audience member has a question, I'll just repeat it so the folks on our live stream can hear it too.
Oh, great call.
Yeah.
You're on the spot now.
I have a question for you.
Oh, great.
If you hadn't become an attorney, what do you think you might have done?
Okay, so the question was, what would you have done if you hadn't become an attorney?
So this is kind of unusual. I was an anthropology major.
So was I.
Oh,
really?
Yeah, like study of culture.
Yes.
Yeah.
Yes. Okay.
So I teach. I'm a professor. I love going to school. So I probably would have kept going to school and got a PhD in anthropology, and probably focused on gender and a particular culture. I think that's probably what I would have done.
So
yeah.
I was a lit major with a minor in anthro too.
Oh, yeah.
The study of man.
Right, exactly. Yeah, like on this meta level. It's interesting.
Can you talk briefly about, so you're using one main case, as I understand it, as sort of a framework for the entire book. Is that correct?
Yeah.
What can readers expect in Manifesto Justice?
Okay, so
Much more than just that one case, I understand.
What can readers expect from the book, given that it is, you're really using the framework of one case, but it's also about more than just that one case?
Yeah, so the focus of the book is acknowledging people who have been wrongfully convicted who, again, may not have the DNA evidence, so what are other tools, and focusing on women and queer people who have been wrongfully convicted and how they are particularly susceptible to being wrongfully convicted. So I have individual chapters focusing on wrongful convictions, specific to women, specific to how women use their bodies, wrongful convictions particular to transgender individuals, particular to queer individuals. I also have a chapter on women in this particular prison in Mississippi and their experiences in prison. So it is broader, but hopefully Lee and Tammy's case kind of ties it together.
Hi, I'm an engineer. I had an engineering undergraduate degree, so I'm going to be a downer. On brand for us. Don't have a humanities degree. I was interested in your commentary about the reforms that have occurred, and we have seen really recently switching from the defense to the prosecutor side. That's just not historically been something that was a trend. And I think it's very absolutely the question. I, as you know, am a resident of San Francisco County, in the city of San Francisco, where on June 7th, next Tuesday, we have to go to the polls for our routine elections, but also a California special, which is recalling all the people who've been in office for less than 2 years that we don't like. And Chesa, our very progressive PA, who is viewed as a reformer, is on the line. This gentleman was elected in January 2020, so he served for a very short period of time, and any kind of even perceived uptick in crime, when it's not actually statistically true, etc., is flame and heat. So I was very excited. People were very excited when he was elected. It was on this trend. That tide has shifted very, very quickly.
Yeah.
I just want to ask if you might comment on that. Why these reform movements seem to be so short-lived, and we seem to turn on them so quickly.
Yeah. So I'm just going to repeat it for the people watching. No, it's okay. So the question is really about the idea that this switch from people doing defense work to becoming prosecutors, and maybe prosecutors with an eye on reform, is very recent. And now there's also a push by a lot of people to kind of move the pendulum back in the other direction. So how do you think about that, and how do you see those trends and how they play out?
Yeah, and I will just say Chesa Boudin did start an innocence commission that has been able to prove and exonerate people wrongfully convicted in San Francisco. So I admire that tremendously, that work. There has been a trend of what's called progressive prosecutors nationally, many of them coming from defense backgrounds. And I think because you're going upstream, there's not nearly as many of them as there is a often dominant culture of overcharging, of not looking at the ramifications of prosecutions, that I think it's been hard, and there has been that pushback. But that said, I feel like the more of these different prosecutors there are that are creating different cultures and different prosecutors' offices, I feel like that's taking root. Even when there's this pushback, I feel like that change in culture has been taking root. And it's just not surprising to have that pushback. But if we're not at least trying different things in our system, then how can we expect the system to work any better? And I guess we'll see what happens on Tuesday. Yeah. Oh, thank you. That's nice.
I'm a phone sociologist here on the other side of the room, and just thinking systematically, right? Because so there's a lot about prosecutors and what's been around, and so I think a lot about how to redistribute the power where the defense attorneys get more, like to readjust the imbalance.
Yeah.
While it's really important to have progressive prosecutors, and I agree with San Francisco, particularly because San Francisco.
Yeah, right.
But so I don't know if you have any thoughts about how we might think about redistributing, or just a little bit equaling the huge imbalance between prosecutors and defense.
Yeah.
So the question was just, we have been talking a lot about ways in which prosecutors can reform, and like what a progressive prosecutor might look like. But what would it look like if we think about redistributing the power so that defense attorneys actually have more power throughout the process?
And I am just going to say one more thing about Chesa Boudin, which is he is the child of people who were incarcerated for many years. So he has that lived experience. And I think that's frequently been rare to have in a prosecutor's office and can provide tremendous insight. So I think that's also a potential shift of people with lived experience, to the extent they can, working in prosecutors' offices. Okay, what can be done? Many people may not know that public defender's offices usually don't have the same funding as prosecutors' offices. So the salaries are not as good as prosecutors, right? The funding for investigation is not as good. Prosecutors have the entire crime lab at their disposal, that they can get the DNA testing. They can do a lot of testing that defense are not able to do unless they get the permission from the court or from the prosecutor. So there's a lot of these things that really can be changed, right? If we shift funding, that it can help in a number of ways. That's not going to alleviate everything, but can make a difference. Oh yeah, done.
Are there certain authors or books that influenced you to go into law? Did you like read about it very recently?
Nancy Drew. I definitely read Nancy Drew as a kid. Oh my gosh.
The question is, what books?
Oh, sorry.
Yeah, were there books that influenced you to go into law?
Oh,
Kill a Mockingbird.
you know what? To Kill a Mockingbird, yeah, definitely read that, and that made a difference too. I love the question, and I'm trying to think of some of the books that would have led to it, but it was really like, we talking about lived experience. It was really my experience with sexual assault, with domestic violence, that I wanted to end, again, in my mind, end those cycles of violence. I felt like being a rape victim advocate, which is very important to me, felt like a Band-Aid of helping someone after they had been harmed. And I was like, let's find the perpetrators and stop, because many sexual assaults are by repeat offenders. Let's find the person, stop the person before they can harm someone else. And I was what would now be called a carceral feminist. You know, I really thought incarceration was going to be the solution and would stop violence against marginalized or vulnerable people.
Such an interesting concept. I had never heard that
word
before. Yeah.
Yeah. Talking about books, Aya Gruber, Feminist War on Crime, came out last summer, and I read it and I was like, oh my gosh, that was me. It's like, that was me. So it is an interesting concept.
Yeah. Was it difficult for you to like turn past that? Because I feel like it is a tough turn for someone to make, to say, you know, I want to see that justice is served. I want to see that someone who does harm can no longer do that harm. And the system that we have for that is a criminal justice system where somebody goes to prison for a period of time. How did you kind of get into your head that you could make that shift, maybe away from being a carceral feminist and more, I don't know if you identify more as intersectional now, or like how you think about it, but that way of saying maybe that there, even though it's painful and difficult to think about it in this way, maybe we have to think about there being a different way in this case too.
Yeah, because it doesn't work. I mean, really. So there are some limited crimes where we truly can put someone away for the rest of their life. And that's our incapacitation answer, where this person is going to be separated out and will never be able to harm another person on the outside again. And that, frankly, most people who are in prison are going to be coming back out, will be back in our communities, have been subjected to violence in prison. And prison is criminogenic. It makes people more likely to commit more crimes. So it is one solution, but it's important to try to think about other solutions that really can get at the heart of why people are violent and how to stop violent behavior. Yeah. I mean, I would, when I was prosecutor, it would upset me to no end that we would have these horrible charges of violence against someone, and we would drop them down to misdemeanors because we didn't think that, so with a misdemeanor, you don't have to have a jury. We didn't think that the jury would be favorable to our victim. You know, our victim wasn't a perfect victim. We didn't think the charges would stick. I mean, we often, survivors, again, don't want to participate. They don't want to go through this process and testifying. So we would drop down these really, there's really notable acts of violence to misdemeanors. And so then what? I mean, what does that do at all? They have a misdemeanor conviction, they serve 6 months. So I just think we have to look at other solutions as well. Yeah. Are there any other questions?
I think I have one more.
I kind of want to call on people.
By all means.
But I won't.
Okay.
I won't. Okay. I know that's not fair. Okay, Sarah, do you have another question?
Oh, I think my only other question was about, you talked a little bit before about DNA evidence and how DNA evidence is like the gold standard to be able to exonerate somebody. But I also know in recent years there's been a lot of conversation about ways in which DNA evidence has been problematic. That DNA evidence has been used to convict someone wrongfully, and now at one time DNA evidence, not even that long ago, DNA evidence was like not possible. Now not only is it possible, but it's so good that even these things called trace DNA, which is like that if I shake your hand and then you go touch a cup later, that my DNA could end up on that cup, and then if that cup is evidence, then I could be convicted. So I'm just also wondering, is there a way that we should be thinking about DNA evidence both as a gold standard, but also as something that can be complicated and tricky?
Yes. I love that you said that. And I think that also goes back to the idea of miscarriage of justice, manifest injustice as a standard of whether a conviction is reliable rather than can we prove this person is factually innocent. Because with these smaller and smaller and smaller amounts of DNA that we're able to test, I mean, they're just infinitesimal. And that's where we start seeing some of those mistakes happening. And we can't deny that either. We can't continue to say, well, this has been so, it's been a perfect tool, right? But when you push it too far and you're trying to get something out of these really small amounts, then that has fallacies as well. And I guess part of the book is about recognizing science changes. I mean, we have hypotheses that change and grow, and our criminal legal system doesn't do that, but it can. Why can't we accept that, we know more now than we did 20 years ago, and that should play a role too. So,
to let things continue to evolve.
Yes.
Yeah, that makes sense.
And to acknowledge it.
Yeah.
Right? Because the legal system tries to just fixate make something a fixture and say, okay, this is the end. We're focusing on finality. It's over. And even we know things change and we have different information later, we're still so attached to that finality. And that may not be serving our communities or our system well. Right. Oh, okay.
How long is physical evidence kept?
Oh, such a good question. Okay, so when I was
question is how long is physical evidence kept? I just want to make sure that people in the stream can hear.
Yeah. No, I appreciate it, Sharon. I'm glad. I forget,
no
so
worries.
Thank you for remembering. So when I was in West Virginia, evidence had to be kept for 60 days after the direct appeal was filed. So that's like months after the trial, 60 days. So every single case, routinely, we would send a letter to the clerk for the courthouse saying, please preserve this evidence. And generally, we would get a letter back from the clerk saying, we have no obligation to preserve this evidence. Now, since we sent the letter and someone cared about it, they generally did. But they didn't have an obligation to keep it. So in West Virginia, it was 60 days. I mean, other states will say not until a conviction is final, so that may be a year, 2 years. But it's so true. In a lot of states, they don't have to keep the evidence, and that evidence is where you're going to get your DNA, right? So it's yet another problem.
So messy.
Yeah.
All right, any other questions before you call on someone? No, I'm just kidding.
Not calling.
Okay.
You're.
So.
Oh, we do have another one. No, it is not. So I am working on another book, which is focused on another one of my clients. who was convicted based on another form of faulty forensic evidence called shaken baby syndrome. And it's also a woman, and she's a little person. So kind of talking about disability and gender, and again, kind of problems of science and not recognizing science as it evolves.
And we do get to meet her in this
book.
Yeah. We get to hear a little bit. So it's exciting to know that she's going to be the subject of the next book.
Yeah. So there is a chapter, you're right, where she's the guide through the chapter. It's actually the chapter on the women in the Mississippi prison. She's your guide through that prison. Yeah.
She sounds interesting.
Yeah.
All right. Well, I know that you're here to sign books also. Thank you all so much for coming, and congratulations.
Thank you very much. Thanks, everyone. Thank you, Sarah.
Thank you.
That was so fun.
That was great. Fascinating. You did a superb job, too.
Thank you so much.
So professional. I know, right?
Oh, I'm so glad. I haven't done an event like this before where it's like live and a book talk. So I was I was really nervous. So I'm glad it worked out really well.
Yeah.